Hello and welcome to Courts This Week by LiveLaw. I'm Debojeet and this is Advocate Awstika. And as usual, in the next few minutes, we'll break down some of the most important developments from courts this week. So without any further ado, let's begin. We have to start this segment with news breaking from the Supreme Court involving environmental activist Sonam Wangchuk. The union government has revoked his detention under the National Security Act, a move that comes while the Supreme Court has been hearing a challenge to that detention. Awstika, what led to this development?
The government stated that Wangchuk's detention was revoked to restore peace and create an atmosphere conducive to dialogue in Ladakh. To recall, Wangchuk had been detained on September 26, 2025 under the National Security Act after what the government described as a serious law and order situation in Leh on September 24. The detention order was issued by the District Magistrate of Leh in order to maintain public order in the region.
And this detention had already become the subject of proceedings before the Supreme Court.
Yes. Wangchuk's wife, Dr. Gitanjali Angmo, had filed a habeas corpus petition in the Supreme Court challenging his detention. Following the arrest, Wangchuk was transferred to Jodhpur Central Jail, where he had been held since last year. The case has been heard by a bench of Justices Arvind Kumar and Prasanna B. Varale, which is scheduled to hear the matter again on March 17th. But in the meantime, the government has now revoked Wangchuk's detention.
And during the hearings, the court had already expressed some reservations about the basis of this detention.
That's right. The Supreme Court observed that the administration may have been reading too much into Wangchuk's speeches. The bench also flagged discrepancies in the translations of those speeches, which were relied upon to justify the detention.
Meanwhile, the government has also pointed out that Wangchuk had already spent a significant period in detention.
Yes. According to the government, Wangchuk has already undergone nearly half of the maximum period of preventive detention permitted under the NSA, which is 12 months. So the government has now chosen to revoke the detention order, citing the need to facilitate dialogue and restore normalcy in Ladakh.
Our next story in focus is a development that will directly affect thousands of judicial service aspirants across the country. The Supreme Court is currently reviewing its earlier judgment that restored the requirement of 3-year practice as an advocate before candidates can apply for entry-level judicial service posts like civil judge. Now, during the hearings, the court directed all high courts to extend the last date of application for civil judge junior division posts until April 30th. Awstika, before we get into the details of the case, can you set the background for it?
Sure. This requirement flows from the Supreme Court's judgment delivered on 20th May 2025, where the court set up the rule that candidates must have a minimum of 3 years of practice at the bar before they can enter the judicial service at the civil judge level. Now, what's interesting is that while hearing the review petitions, the court made it clear that the existence of the rule itself isn't really under challenge. Chief Justice of India Surya observed that since the mandate comes from a Supreme Court judgment, it has to be respected. The real question right now is how the rule should actually be implemented.
Right, and the Chief Justice also made an observation about why this rule exists in the first place. Could you walk us through that reasoning?
Yeah. The Chief Justice of India said the whole point of requiring practice is that you learn something before becoming a judge. The idea is that real courtroom experience helps future judges understand procedure, litigation strategy, and how the system functions in practice, as opposed to just having a bookish knowledge of things.
At the same time, there seems to be a lot of pushback against this rule. What did the court hear from the amicus and other stakeholders?
Senior advocate Siddharth Bhatnagar, who has been appointed as the amicus curiae in this matter, informed the bench that most high courts actually support the 3-year practice requirement. Some high courts have suggested limited relaxations for candidates with disabilities, but several law universities have opposed the requirement. For instance, through Chanakya National Law University, Professor Faizan Mustafa suggested an alternative model, removing the practice requirement but increasing the training period for civil judges.
And there were also concerns raised about how this rule might affect aspirants, especially women candidates.
Yes. Senior advocate Pinky Anand told the court that the requirement could create serious practical hardships. Since judicial exams are not held regularly every year, adding a mandatory practice period could increase the age at which candidates enter the judiciary. She also argued that this requirement may disproportionately affect women aspirants and suggested that the court consider staying the rule while the implementation framework is reconsidered.
Interestingly, the Chief Justice himself acknowledged some of these concerns, particularly about how law graduates might respond to this rule.
That's right. Chief Justice Surya observed that many bright law graduates are now choosing corporate careers instead of waiting 3 years to become eligible for the judiciary. He also suggested that perhaps the rule could have been introduced in a phased manner, starting with a 1-year requirement, then 2 years and eventually 3 years. According to him, imposing the full 3-year mandate at once has created significant pushback among students and law schools.
So it looks like the court is trying to strike a balance here, but leaning more towards retaining the 3-year rule.
Looks like it, but we'll find out more in the coming days. The principle of practical legal experience before joining the bench remains important for the court. But the ongoing review will likely focus on how to implement the rule in a way that remains fair and workable for future judicial officers.
Let's move to a historic ruling from the Supreme Court this week, a ruling that deals with the sensitive issue of passive euthanasia and the right to die with dignity. The court has allowed the withdrawal of life support for a 32-year-old man who has been in a permanent vegetative state for more than a decade. Awstika, can you tell us what exactly happened in this case?
Of course. So, a bench of Justices J.B. Pardiwala and K.V. Vishwanathan permitted the withdrawal of life support for Harish Rana, who has remained in an irreversible vegetative state for the last 13 years. The court noted that Rana was once a bright young man whose life changed after he fell from the 4th floor of his paying guest accommodation. That accident caused severe brain injury, leaving him in a persistent vegetative state with 100% quadriplegia. For years, he has been bedridden, breathing through a tracheostomy tube and receiving nutrition through surgically inserted PEG tubes, with medical reports showing no improvement.
And this case is being described as legally significant because it happens to apply the Supreme Court's earlier euthanasia guidelines.
Yes, this is the first time the Supreme Court's guidelines from the Common Cause judgment from back in 2018 have been judicially applied. In that judgment, the court had recognized passive euthanasia and laid down procedures for withdrawing life support in certain cases. Here, the court clarified that clinically administered nutrition, or CAN, is itself a form of medical treatment. Since Rana's life was being sustained only through CAN, it could legally be withdrawn if medical experts recommended it.
So how does that process actually work under these guidelines?
The decision must first be evaluated by a primary medical board and a secondary medical board. If both boards unanimously agree that life support should be withdrawn, the court said that judicial intervention is normally not required. However, because this was the first case applying those guidelines, the matter was placed before the Supreme Court.
And the court also issued several directions to ensure the process happens in a dignified manner.
Yes, the court directed that clinically administered nutrition be withdrawn and asked AIIMS to admit the patient to its palliative care center so that the process can be carried out with proper medical supervision. It also instructed that the withdrawal of life support must be done through a carefully tailored plan that preserves the patient's dignity.
The bench also made some broad observations too, I think.
Yes, about that. Beyond this individual case, the court did issue broader directions. High courts across the country must ensure that judicial magistrates receive intimation from hospitals whenever medical boards decide to withdraw life support under the Common Cause guidelines. The union government was also directed to ensure that district chief medical officers maintain panels of doctors who can serve on these medical boards.
And before closing the case, the court made a very moving observation about the patient's family.
Yes, the bench recorded its special appreciation for Harish Rana's parents, acknowledging the immense love and care they had shown their son over the past 13 years. It was a reminder that behind every constitutional principle and legal procedure, there are very human stories.
Let's turn to another important development from the Supreme Court this week, and this time it's concerning representation of women lawyers in bar associations across the country. The court has now taken an important step to ensure that the 30% representation mandate for women is actually implemented. Awstika, what exactly happened here?
The Supreme Court has now empowered district judges across the country to nominate women lawyers to the executive committees or governing bodies of bar associations within their jurisdictions. This order was passed by a bench of Chief Justice Surya and Justice Joymala Bagchi. The idea is simple. If elections are held where the 30% representation requirement for women is still not met, district judges can step in and nominate women members to fill that gap.
So essentially, if women lawyers are available but for some reason are unable to contest elections, the court doesn't want the representation mandate to fail.
Exactly. The court specifically said that where sufficient women lawyers are available but cannot contest the elections for some reason, district judges can nominate them so that the executive bodies of bar associations still meet the 30% threshold.
And this order actually comes after the court reviewed compliance reports from high courts, right?
Yes. Earlier, the Supreme Court had asked Registrar Generals of High Courts to verify whether bar associations were complying with the 30% representation requirement. Senior Advocate Jaina Kothari, who is assisting the court in this matter, informed the bench that while some high courts filed detailed reports, others submitted very sketchy responses. In fact, the court noted that only 11 high courts had filed proper compliance reports.
Which means the representation mandate still hasn't fully translated on the ground.
Precisely. The court also observed that the benefit of representation has not fully percolated to several specialized bar associations, including those dealing with tax, RERA, DRT, and NGT matters. So the Supreme Court has now directed the remaining 14 high courts to ensure that all bar associations within their jurisdictions implement the 30% representation rule for women lawyers in their governing bodies. The court's intervention is aimed at ensuring that gender representation within the legal profession moves beyond policy and actually becomes a reality inside bar associations across the country.
Another interesting discussion played out in the Supreme Court this week around a topic that often comes up in policy debates: menstrual leave policies in workplaces. A petition had asked the court to direct the government to introduce paid menstrual leave for women across all establishments. But Awstika, how did the court respond to that request here?
The Supreme Court ultimately disposed of the petition and asked the central government to consider the petitioner's representation and examine whether a menstrual leave policy should be framed in consultation with all stakeholders. But during the hearing, the bench of Chief Justice Surya and Justice Jayamala Bagchi expressed strong observations about whether such a mandate should come through a court order.
And the court also questioned the petition itself too.
Yes, quite bluntly actually. The bench questioned the locus of the petitioner, Shailendra Mani Tripathi, noting that no woman had approached the court seeking this relief. The judges also pointed out that this was actually the third petition filed by the same petitioner on the same issue. Earlier petitions had already been disposed of, with directions allowing him to make representations to the government and asking the union to take a policy decision.
But the most striking part of the hearing was the court's concern about possible unintended consequences of making menstrual leave mandatory.
Exactly. Chief Justice Surya observed that making menstrual leave a compulsory legal requirement could actually end up harming women's careers. He cautioned that employers might begin to see women employee as a less attractive resource if mandatory leave obligations are imposed. Justice Jayamala Bagchi echoed this concern, saying that while affirmative action for women is constitutionally recognized, one must also consider the practical realities of the job market.
The petitioner's side, however, argued that similar policies already exist in some places.
Yes. Senior advocate M.R. Shamshad told the court that Orissa has had a menstrual leave policy since 1992. Karnataka recently introduced such a policy, and some schools in Kerala have also granted relaxations. He added that several private organizations voluntarily provide menstrual leave.
But the court seemed to suggest that voluntary policies might be the better route.
That's right. The Chief Justice said voluntary initiatives are welcome, but imposing menstrual leave through a mandatory legal framework could have unintended long-term consequences for women's employment opportunities. But I have to say something on this, Debojeet. Critics say that this concern may be overstated, especially since menstrual leave itself, like maternity leave, is a policy specifically meant for women. Whether such a change should come from the judiciary or through legislative intervention is a valid concern. But criticizing the policy itself on its merits seems a little misplaced in my opinion. For example, Spain addresses this concern by compensating companies and bearing the cost of menstrual leave to prevent this kind of hiring bias that the judges were talking about. For now, in India, the Supreme Court has left the issue to policy making by the government rather than judicial direction.
Let's now move to a very important judgment from the Supreme Court that could impact reservation benefits for OBC candidates appearing in competitive exams like the civil services. The court has clarified that parental salary alone cannot be used to determine whether someone falls in the OBC creamy layer. Awstika, what was the dispute here?
So this case involves several candidates who had cleared the civil services examination and claimed reservation under the OBC non-creamy layer category. However, when their documents were verified, the Department of Personnel and Training treated them as belonging to the creamy layer. And the reason for this was their parents' salary. Many of their parents were employees in public sector undertakings, banks, or similar organizations.
So essentially, the government concluded that because the parents were earning above a certain income level, the candidates could be treated as creamy layer candidates.
Exactly. But the Supreme Court disagreed with that interpretation. A bench of Justices P.S. Narasimha and R. Mahadevan dismissed the union government's appeals and granted relief to the candidates. In the judgment authored by Justice Mahadevan, the court clearly said that creamy layer status cannot be determined solely on the basis of income.
And the court relied on the framework created after the famous Indira Sawhney judgment, right?
Yes. The court referred to the 1993 Office Memorandum, which was issued following the Indira Sawhney case. That framework primarily looks at the status of the parents' posts, not just income levels. For example, children of Group A officers or certain Group B officers who are promoted early are considered creamy layer. The same principle applies to equivalent positions in PSUs, banks, universities, or even private employment, but only after determining whether those posts are actually comparable to senior government posts.
So, what the court is essentially saying is that salary figures alone cannot be mechanically applied.
Yes, that's right. The court warned that salary income cannot be mechanically aggregated in a way that defeats the constitutional objective behind reservations. It also pointed out that Group C and Group D government employees whose salaries increase over time are not automatically excluded from reservation benefits.
And if the government's interpretation had been accepted, it could have led to some strange results.
Absolutely. The court noted that under the interpretation, children of PSU or private employees could be excluded purely because their parents' income crossed a threshold, even if their posts were actually equivalent to lower government service categories. The court held that such treatment would violate Articles 14 and 16 of the Constitution, which guarantee equality.
And the court also reminded everyone what the creamy layer concept is actually meant to achieve.
Yes, the bench emphasized that the goal of excluding the creamy layer is to prevent socially advanced sections within OBCs from capturing reservation benefits meant for the genuinely backward, not to create artificial distinctions among people who belong to the same social class.
Let's now turn to a development that many UPSC aspirants were closely watching. The Supreme Court recently dealt with a plea seeking an extra attempt in the civil services examination for candidates affected during the COVID-19 pandemic. Awstika, what exactly was the petitioner asking for?
This petition was filed by Jaimin Patel, a civil services aspirant who said he was directly affected by COVID during the examination cycle. He requested the court to direct the government to set up an interministerial committee to examine whether candidates whose last permissible attempts fell in 2020 or 2021 should be given a one-time additional attempt in the UPSC Civil Services Examination 2026 along with corresponding age relaxation.
And the argument was that the government had not properly reconsidered this issue despite earlier directions.
Exactly. The petitioner argued that even after earlier judicial directions in the Arijit Shukla case, parliamentary recommendations and available data showing which candidates were affected during the pandemic, the government had not initiated the mandatory consultative process required under Article 77(3) and the Government of India Allocation of Business Rules 1961 among them. He also told the court that he had contracted COVID in and was denied leave to appear for the exam in 2021, which meant he lost his final attempt both in terms of age and number of attempts.
So how did the Supreme Court respond to this request?
The court ultimately refused to entertain the petition. The key reason was delay. The bench noted that the petitioner had approached the court almost 5 years after the events in question. And because of that delay, the court declined to intervene or direct the government to reconsider the matter. So the possibility of a special additional attempt for candidatures whose final chances fell during the pandemic appears unlikely through judicial intervention.
Let's now move to another interesting hearing in the Supreme Court, this one dealing with railway passenger welfare. The court raised an important question. Why is travel insurance available for passengers who book tickets online but not for those who buy tickets at railway counters? Awstika, what triggered this discussion?
This issue was raised before the court by senior advocate Shikhil Surya, who was assisting the bench as amicus curiae. He pointed out that passengers who book tickets online can opt for travel insurance by paying a very small additional amount, but the same facility is not available to people who purchase their tickets physically at railway counters.
Which effectively creates two categories of passengers depending on how they buy their tickets.
Exactly, and that is what concerned the court. A bench of Justices Ehsanuddin Amanullah and R. Mahadevan observed that there cannot be a distinction based on the mode of purchasing a ticket. The judges clearly stated that granting insurance to one segment of passengers and denying it to another simply because one booked online and the other bought a counter ticket is not justified.
The railways, however, did try to explain why the difference exists.
Yes. The railways argued that when tickets are bought at counters, identity details may not always be recorded, which could potentially lead to misuse or fraudulent insurance claims. But the court indicated that such concerns cannot be used as a blanket reason to exclude an entire class of passengers from the benefit.
And the hearing didn't stop there. The court also seemed quite unhappy with the railways' response on another issue.
That's right. The bench expressed dissatisfaction with the affidavit filed by the railways regarding its spending priorities. The judges said that even after examining the affidavit, they could not clearly understand how funds were being allocated or utilized.
Which is a fairly strong observation from the court.
Absolutely. The court remarked that the material placed before it seemed to project matters in a particular way without addressing the larger public interest or the concerns raised by the court. And importantly, the bench reminded the railways that these proceedings were for the common man who will be using the facilities of the railways and not the privileged few. So the court has now essentially asked the railways to come back with clearer explanations and a more transparent account of how passenger welfare measures are being implemented.
Let's now move to a deeply troubling case from Madhya Pradesh that reached the Supreme Court this week. The court has ordered a CBI preliminary inquiry into the death of a 20-year-old woman, and the allegations surrounding the case are extremely concerning. Awstika, what exactly was placed before the court?
So the case stems from an incident dating back to 2019 when the woman, who was only 15 years old at the time, allegedly accused a close aide of BJP MLA from Madhya Pradesh, Bhupendra Singh, of molestation. According to the plea filed before the court, even though she was a minor at the time, provisions of the POCSO Act were not invoked in this case.
And the petition also describes a very disturbing chain of events that followed.
Yes. Senior advocate Colin Gonsalves, appearing for the woman's mother, told the Supreme Court that 3 members of the family were later murdered after they refused to withdraw the molestation complaint. 2 of those victims were the woman's brother and uncle, who were key witnesses in the case.
And there were also allegations about political influence and interference in the investigation.
That's right. Gonsalves alleged before the court that the killings were carried out on the instructions of Bhupendra Singh, who is now an MLA in the area. He also claimed that the public prosecutor had sabotaged the prosecution by asking eyewitnesses not to name the accused persons, and argued that local police could not be trusted to conduct an impartial investigation.
The circumstances of the young woman's own death were also placed before the court.
Yes, the petitioner, the victim's mother, told the court that the woman later died after she was allegedly thrown out of an ambulance while travelling with her uncle's dead body during protests against the killings. According to the plea, no FIR was registered regarding her death, and the police merely conducted a preliminary inquiry before closing the matter.
But the state of Madhya Pradesh presented a very different version of events.
Exactly. Additional Solicitor General S.V. Raju, appearing for the state, argued that the former minister was being politically targeted and claimed that the woman had actually jumped out of the ambulance herself and died.
Given these sharply conflicting narratives, the Supreme Court has now stepped in.
Yes. Taking note of the seriousness of the allegations and the questions surrounding the investigation, the court has directed the CBI to conduct a preliminary inquiry into the circumstances of the woman's death.
And for our final story, which is another constitutional question that came up before the Supreme Court this week dealing with Muslim inheritance law and gender equality. The court briefly heard a petition challenging provisions of the Muslim personal law as discriminatory against women. Awstika, what exactly is the issue that the court is examining here?
The petition challenges provisions of the Muslim Personal Law Sharia Application Act 1937, arguing that they result in unequal inheritance rights for Muslim women. Under traditional Sharia inheritance rules, a woman generally receives only half the share of a male sibling. The petitioners argued that this position has now become even more problematic after the Uniform Civil Code enacted in Uttarakhand in 2024.
Because that law creates a different set of rights for Muslim women depending on where they live.
Exactly. The petition points out that a Muslim woman living in Dehradun would inherit equally with her brothers under the Uttarakhand UCC, while a Muslim woman living in Delhi or other states would still inherit half the share under Shariat law. So according to the petition, this creates 2 different civil right regimes within the same community based purely on geography.
During the hearing, the judges seemed to raise some important constitutional questions themselves.
Yes. A bench of Chief Justice Surya, Justice Joyamalla Bagchi and Justice R. Mahadevan first asked whether the court can actually adjudicate the constitutionality of a personal law practice. Justice Bagchi even referred to the Narasu Appamalli judgment of the Bombay High Court, which has held that personal laws cannot be subjected to constitutional tests under Part 3. But the petitioners argued that the court can intervene. Advocate Prashant Bhushan relied on the Supreme Court's 2017 Shaira Banu judgment, which struck down instant triple talaq. He argued that the court cannot accept a situation where Muslim women continue to have unequal inheritance rights compared to men. He also argued that inheritance is essentially a civil right, not an essential religious practice protected under Article 25.
The court, however, seemed concerned about what might happen if the Shariat inheritance provisions are struck down.
Yes. Chief Justice Surya raised a concern that striking down the provisions could create a legal vacuum, since there is currently no separate statutory framework governing Muslim inheritance, unlike the Hindu law, where we have Hindu Succession Act. Justice Bagchi also suggested that such reforms may ultimately fall within the domain of the legislature, especially given that the Constitution itself speaks of a uniform civil code as the directive principle.
So what happens next in this case?
The court has asked the petitioners to amend their plea and suggest possible remedies in case the Sharia inheritance provisions are struck down. The matter has been adjourned for further hearing.
And that's a wrap on the biggest courtroom developments this week. But remember, for detailed reports of all the cases that we talked about today, visit livelaw.in and keep following us on all our socials to stay updated with everything that is law.